Hello and welcome back to this final part of What Do I Know? Why did CEC's investigations into HPC fail and be declared unlawful? This is ground 12, the final part of this report and findings. We've got there to this last one, and I'm going to dive straight in and give you ground 12. Ground 12. Allowing the publication of investigatory reports with allegations not supported by any evidence. Oh dear. I'm going to let you know before I read this out that I actually was called upon to lend a lot of expertise in this, and my knowledge regards rules of evidence, both from my walk of life as a solicitor and as a professional investigator. So quite a bit of this is in here from my expertise and two others. But we'll go straight in. In order to understand this ground further, I'll start again. In order to understand this ground, further qualification is required. What is meant here is that the investigation reports have been published with either 1. Wholly dishonest statements given with an aim to mislead, 2. Wholly dishonest statements given to deliberately defame another party or parties, 3. Statements made which are dishonest and which should have been noted as such given evidence to the contrary, 4. Provably dishonest statements allowed to stand, thus occasioning potential liable damage. 5. Statements which are dishonest are not revisited by the investigator. And 6. Statements made that have not been proved or qualified by the investigator as being accurate. So from that you can see there's some big failings. When an investigator writes an investigation report, he or she must ensure that what is written is true, correct and accurate. The taking of statements, carrying out of interviews and writing of the report must be carried out by an experienced investigator. Well, we didn't have that, did we? As you found in ground 8, basically what we had is an unqualified, brain-dead idiot doing it. The investigator must take into account the full definition or area of law or set of circumstances they are investigating. They also need to take account of the rules of evidence in that they need to know the rules of hearsay and opinion and the differences there between them both. Hearsay is defined in section 1(2) of the Civil Evidence Act of 1995 as evidence that it is a written or oral statement made otherwise than by a person giving oral evidence in proceedings which is tendered as evidence of the matters stated. What is opinion in terms of evidence? The general rule of evidence is that a witness may give evidence of facts within their direct knowledge, but they may not express an opinion. Opinion can be evidenced by non-expert witnesses who, in describing facts, express an opinion on matters within the competence of lay people. With opinion, an investigator must take measures to ensure the veracity. I'm hoping John Smith got that word veracity, because he once in a parish council asked what did veracity mean, because he didn't know it. And yeah, we've got a video of that, by the way. I might have to put that up. Of said evidence. He or she cannot just accept it as it is. The correctness and honesty of the evidence must be ascertained. They also need to be able to detect dishonesty when it arises. Yep. You also need to ensure that any statements to be exhibited to the report or reports are submitted in the correct form, i.e. as lawfully taken witness statements. When taking witness statements, and this is one mark from me, there are 5 easy steps that must be followed, and that can be abbreviated into the acronym PEACE, P-E-A-C-E, and that stands for Preparation, Engage and Explain, Account, Conclude and Evaluate. So, preparation means prepare for the statement. Have you got the facts, information and evidence obtained so far? Prepare the witness. Not lead, prepare. What does engage and explain mean? This means you support the witness. You explain stuff to the witness. You explain the process that's going to be going through. A is account. Account means you verbally listen to their account. You probe. You probe and you clear up any ambiguities, and you make sure you fully understand everything that the witness will say, and then you make a formal written statement and you get the witness to swear to it. Sign it. See, you conclude. You revisit that statement and you revisit it with the witness. You go over it with the witness. Moreover, you make sure that what they have said is supported. You make sure they are supported as well. Conclude. Sorry, don't conclude. And finally, evaluate. What do we mean by evaluate? Well, evaluate means, what has the witness provided you? Have you got any information that will need to be corroborated? Is the information contradictory? Is the information give you the hint or the concern or set your alarms off that it's dishonest, fabricated, doctored? Do you need to make up any, do you need to make any follow-up inquiries? I.e., are there any more reasonable lines of investigation that you think you're going to have to walk down? So you follow a piece, and you follow it rigidly when you're doing all of that. The assessment has evaluated the statement. The assessment has evaluated the state of the statements included in the appendices of the reports. The results of the said evaluation will be noted in the conclusion to this ground. Of further importance, when investigation reports are written, the investigator must ensure that he or she fully complies with the law of defamation. Defamation is a spoken or written statement by an individual or business that turns out to be false but is harmful to their reputation. There are two types of defamation. We have slander and libel. Slander, spoken words or comments. Libel is written. Yeah? And the thing is, you easy remember those. Slander, spoken. Libel, literary, because it's written. Okay? And libel can be words that are written or broadcast. The Defamation Act of 2013 sets out the law of defamation. The law states that a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. In this case, the fact that the investigation report is written would mean that should an investigator publish statements in his or her report that are inherently untrue to the extent that it does serious harm to the reputation of a party or parties, then they could be liable to be sued for libel. The same can be said for the investigators instructing client if they have accepted and then published the same said reports which contain the defamatory statements. There are 5 elements which need to be shown to prove defamation. 1. A false statement of fact was made. 2. The statement was communicated to a third party. 3. The defendant was negligent or acted with absolute malice in determining the truth of the statement. 4. The statement was not privileged. And 5. The statement caused some type of damage. The assessment goes on. We now address each of these elements separately. 1. A false statement of fact was made. The first crucial element of defamation that you must prove is that a false statement was made by the defendant and presented as a fact. In other words, somebody's lied, know they've lied, but have published it knowing it's wrong. 2. The statement was communicated to a third party. Well, here the communication of the false statement is one of the most crucial elements of defamation. If a false statement was made, but there was no one to hear it, then it wouldn't cause any harm and would not be a defamation. However, statements can be communicated to a third party orally in written form. If the defamation occurs in written form, then of course we know it's libel. If it is oral, then we know it is slander. Literary or spoken, easy to remember. The distinction is not always clear. So the distinction is not always clear-cut in the digital age, but an experienced defamation lawyer can help you determine if you were the victim of slander or libel so you can make the right kind of defamation claim. The assessment put that in as a little bit of guidance for myself, Barry and Brian and my father. So that's why that was in the report. 3. The defendant was negligent or acted with absolute malice in determining the truth of the statement. You also have to demonstrate that the defendant who defamed you failed to fulfil their obligations in determining if the statement was true or not. There are different standards used to establish a defendant's obligation depending on if you are a public figure or a private figure. Private figures and the negligence standard. If you are classified as a private figure rather than a public figure, you only need to show that the defendant in your defamation claim was negligent or careless in determining whether or not the false statement was true. If a reasonable, prudent person or entity would have been more careful in ascertaining the truth of the statement, then you have satisfied the element of your defamation case. You can demonstrate that a defendant was negligent by showing evidence in relation to the level of care the defendant took in fact-checking, the amount of research the defendant did prior to the publication of said statement, and 3, whether the defendant made an attempt to verify published information. If the defendant did not follow basic journalistic practices or otherwise did not exercise a reasonable degree of care, this element of your defamation claim will be satisfied. Again, they've put a nice little advisory paragraph, so a short 2-liner in there for us. Public figures and absolute malice. If you're a public figure, a different standard is used called the actual malice standard. When this standard applies, you can successfully make a defamation claim only if one of the following is true. The defendant published a false statement of fact with the knowledge that it was false, or the defendant acted with reckless disregard for determining whether the statement was false or not. This is beyond mere negligence. The defendant must have entertained or had reason to entertain serious doubts about whether the statement was true or not. This standard applies to public officials, such as those who have positions of authority in the government or who have held positions of authority even if they have left office. All-purpose public figures include those who have achieved widespread notoriety due to the level of their fame. Well, were we a public figure? Probably because we were public officials. 4. The statement was not privileged. Some types of communication are considered to be privileged or entitled to special protections under the law. Big example, statements in Parliament, statements in the Council Chamber. However, when I say Council Chamber, that doesn't apply to parish councils. No. If a defamatory statement is privileged, then a plaintiff will not be able to make a defamation case based on it. Some statements are absolutely privileged, so they can never be grounds for a defamation lawsuit. Examples include testimony presented in court proceedings and statements made by government officials when the legislature is in session. These statements are privileged because it is in the public interest to provide strong protection for speech in those situations. Qualified privilege also applies to some statements. Qualified privilege applies when there is strong public interest in the subject matters, so free communication on the issue is critical. The statement caused some type of damage. Finally, you must demonstrate that the statement caused you to experience actual damage. This can involve showing that it caused them reputational harm, lost future opportunities, or severe distress necessitating medical treatment. Hello. Before proceeding to address who has been affected and how and who is getting to the impact statement, it is necessary to note the results of the analysis of the reports in line with the 6 criteria presented at the beginning of this part of the report. The findings are noted below. We took the first report, the Clark and BT and BB. The figure I'm going to give you is a number of occurrences matching the 6 criteria. In that first report, 48. Second report, Sampson, Smith and Moore against and Tolver, Bruton and Burkill, 53. Tolver, Bruton and Burkill and the Sampson, Smith and Moore, the third report, 57. In the report regards Brian Tolver regarding 10th of December 2020, we find 65. These are the assessment findings. AB, read the 10th of December 2020, 65. Barry Burkle, read the 10th of December 2020, 65. So we're looking at some high numbers there. And certainly, if that was provided to me in my annual report I'd written, and those occurrences were like that, I'd be rewriting that report double quick. Those numbers have been added up, and that makes a combined total of 353 occurrences when those 5 or 6 criteria for defamation were absolutely satisfied. So we've got reports here that are quite clearly highly defamatory. They then list 12 examples of statements found to be matching the criteria, and these include 1. Deliberately missing of evidence by the investigator. 2. Failure to consult with counsel as regards rules of requesting the calling of meetings. 3. False accusations of attempting to block meetings. 4. Failure to confirm the accuracy of statements with evidence. 5. False accusations of bullying. 6. Falsely accusing someone of swearing with no evidence. 7. Assessing tainted and manipulated evidence to draw dishonest conclusions. 8. Falsely attributing statements and events to parties. 9. Failure to correctly assess allegations made. 10. Failure to address and appreciate evidence in supporting dishonest views. 11. Failure to note the admission of criminal offences. And 12. False and unproved allegations against named parties not involved in the investigation. This is not an exhaustive list by any means, but covers the main areas and headings under which the occurrences fell. Before consideration turns to who was affected and how, there was one other critical point which must be explored and cannot be overstated. That point is simply this: where the investigator is in receipt of either hearsay or opinion evidence, he or she has to take steps to qualify it. This means that he or she must take proactive steps to ensure that the evidence is absolutely true. The strongest way of doing this is by taking a witness statement from the party or parties that have given the evidence. Within that witness statement, the steps to be taken to prove the evidence correct and honest should be explicitly recorded. The most common ways of recording is by noting the steps. The investigator should write in the witness statement the following. They should write: at this juncture I noted the allegation made by, and you insert the subject name. I asked, insert the subject name, if they would substantiate their allegation with evidence that will show it to be true. What comes next is critical, as this will indicate whether or not the statement was backed up by credible and strong evidence, or simply if it was not. Depending upon the circumstances and answers to the above inquiry, the investigator must write either of the following statements. Insert the subject name, or the subject matter, has supplied me with evidence that proves their allegation is true. I exhibit this to the witness statement marked, and you put the exhibit number. Or insert the name of the subject matter name, has not and cannot supply me with any evidence that substantially proves that their allegation is true. In the absence of evidence, I can only accept this as a statement of opinion and not prove fact. I advised, and you put the subject matter name, that I was making this note in their witness statement and explained to them what it means and its effect. 2 big statements. I use those very commonly, and I do because I have to, because I'm doing my job, and it's what is honest, open, transparent. Both these statements are self-explanatory and are easy to understand. One confirms that the subject did give evidence to substantially prove the veracity, there's that word, I hope John Smith looked it up, and validity of the statement, so as to turn it from being opinion to credible and acceptable evidence exhibited to their witness statement. On the other hand, where the party cannot provide evidence to prove what they have alleged, is true, the investigator notes this and places this on record that their allegation is just going to be treated as an opinion and not actual evidence. Addressing statements or allegations in this manner avoids the publication of defamatory evidence. Of course, it is recognised that the subject could forge evidence. If that does happen and the investigator surprisingly does not see or recognise it, or recognise that the evidence is forged, then the investigation and its report would be invalid or invalidated by the presence of that evidence. The investigator will face questioning as to how he or she missed it. If, on the other hand, the investigator does recognise and see the evidence that has been presented has been forged or has been significantly altered or amended, then he or she must note this in the report and in the witness statement. The investigator should also report this to their instructing client and then consider reporting it to the appropriate authority. The same applies where another party to the investigation advises that there is evidence present and that has been dishonestly amended and or altered. Now we get to the impact statement, the final one. And before I forget, I'm not off duty. I'm still on duty. I'm not a counsellor, but any good counsellor will tell you, yeah, I know somebody now who more than likely he will be off duty. He's probably been off duty since dinner time, yeah, but I'm still on duty. So who was affected? Who? 3 people were affected. The late Councillor Tolver, the late Councillor Burkill and the former Councillor Brereton. How were we affected? In order to achieve full comprehension of the effects on us, this set of serious issues will be addressed in separately numbered paragraphs to avoid confusion. Paragraph 1. The investigator knowingly and without any explanation missed evidence that we had handed to him, or he deliberately chose to ignore it, citing the excuse that it fell outside the scope of his instruction. This astonishing and deliberate ignoring of evidence meant that we could simply not defend ourselves. Our right to a fair hearing vanished. It was gone. The investigator was not conducting a fair investigation, and this ignoring of evidence without sound reason led to reports being published which incorrectly stated that we were in the wrong when we simply were not. It also allowed for reports to be published which were inherently dishonest. 2. The investigator's failure to consult us thoroughly on the rules for requesting and calling of meetings directly led to a dishonest finding that BT and AB had colluded to block the calling of meetings. This was an entirely false statement of fact and a gross misrepresentation of what the actual situation on the ground was. Once again, we were open to ridicule in the media and on social media. We were wrongly and dishonestly accused of blocking or refusing to call meetings. This was all because the investigator yet again accepted opinion evidence instead of actual evidence, or chose to ignore evidence which showed and demonstrated the truth. We were horrendously defamed, which didn't just cause detriment to us personally, but also to our families and friends. 3. The investigator noted in one report that AB refused to agree to an interview, but then cites no reasons why this happened. This is extremely serious, as this inexplicable omission led to right-thinking reasonable persons to believe that AB had simply refused. The investigator, through his own negligent omissions, openly promoted dishonesty against AB, me. He allowed the very idea that AB had just refused to comply but be published when he knew this to be false. This was further defamation of AB and left AB open to ridicule and to receiving harassing and threatening messages from strangers on his Facebook Messenger. This led to AB deciding that yet again he would not go out of his own home on his own. That was back then. And I can tell you now, I got an email, and it was at the beginning of March of 2021, inviting me to a 3-on-1 meeting with investigator David Kitson and a trainee. And do you know what? Kitson and Robinson were so man enough, so tough, they let the trainee write it. No, bad form. There was no way in the world I was going to a 1-in-3 meeting. I don't know what planet they were living. I don't know what they'd been smoking, what they'd injected, what they'd imbibed, what they'd snorted, But I tell you what, they were not in the realms of reality, because that simply doesn't happen. 1-on-3s don't happen. I'm sorry, they don't. I mean, they must have been. I don't know know what police drama, whether it be British, American, whatever they were watching, but they were not in the real world sending me that email, and I was well within my rights to say, absolutely not. You can go and take a running jump, and that I didn't refuse to attend that. I decided not to attend it because I knew full well, with it being a 3-on-1, and I'd not had the complaint served against me, that my right to a fair trial was not being upheld. I didn't need my solicitor to tell me, even though he did back me, as did my barrister and our legal team, to say, look, no, I'm not doing that. So that's the real truth behind that. That didn't go in the report, man. In the report, that's dead in the water now. So, yeah. Paragraph 4. AB was falsely accused of swearing. There's been no evidence given to support this scurrilous and unfounded accusation. From my point of view, I know I did not swear, and I have witnesses to that. There was no explanation in the reports as to how this conclusion was reached. I was just falsely accused and found guilty of doing something I did not do. This caused me further great distress and played a major role in me suffering PTSD. I can tell you now that Brian Tolver, before he died, undertook a voice recognition test. Well, I have disclosed in a previous video, we know who swore. And all I'm going to say is, that person currently sits on Hanforth Clown Council. No, he's not off duty. Many probably thinks he is. But put it this way. All you've got to do is look south and you find him. Paragraph 5. BT, BB and AB all noted that statements and events of a negative nature were falsely attributed to them. Again, this act was dishonest and the assertions that were made were defamatory. Untold damage was done to our good reputations and the stress it caused was enormous. We had stuff that was attributed to us that was just rubbish, that didn't happen. And there's a mountain of evidence out there that showed that. This went before this assessment at this time, and it was just, seeing their reaction was just absolutely unbelievable. Yeah. How could these reports be written? How could these statements be put in it? It's easy. Robinson and Kitts and Bevan Brick were brought in as troubleshooters, and the MO wanted to troubleshoot it and didn't care whether he did it honestly or not. Paragraph 6. AB was falsely accused of bullying. When you've got someone who is willfully breaking the law or committing acts of gross misconduct, you have to stand up against them. That is exactly what I did. There was no consideration of the difference between being assertive and bullying. I had to assert what was right and correct. In my role as Chair of Finance, I had to protect the public purse, and the clerk was found to be misspending money as well as supplying incorrect accounts and account statements. I considered what was happening and decided that I could not stand back. If I could not stand up and protect the public purse without being persecuted, then there is something radically wrong. As for the second case of bullying, we were faced with someone who was not appointed to any office and was committing a criminal offence. That's Jackie Weaver. She was recklessly, willfully, and by admission unlawfully interfering in the democratic process. She undermined and disrespected the officers of the council. I had every right, as did BT, to stand up to her. That was not bullying, but was rightfully assertive. If I was bullying her, Mrs. Weaver wouldn't have gone ahead with the meeting. She would have refused and played the bullying card. Simply put, she didn't. Again, I was made the subject of dishonesty and was defamed for no reason. Well, I am proud to say that this assessment found me innocent of bullying. So no finding of bullying now rests or lies against me or my character or reputation. So I didn't bully anyone. 7. The investigator also made an unprofessional and personal slight and attack against AB. He stated that my fraud knowledge was poor. Yeah, right, whatever, mate. That damaged me professionally, as I specialise in fraud investigations to a very, very high standard and level, and no one has ever doubted my ability or my knowledge, and they haven't. No. 8. The investigator used a manipulated and mutilated version of the video of the meeting of the 10th of December 2020. The transcript shows that things are happening in the wrong order. This makes the evidence tainted and therefore inadmissible. It was dishonest to use that evidence against us. There should have been a huge effort made to discover the correct course of things. The end result was that we three have had to suffer seeing articles written in the media with multiple different versions, none of which were honest, and which has caused us untold stress and distress. 9. And this is the final paragraph of the impact statement before we hit the conclusions. 9. Jackie Weaver admitted to a criminal offence which should, in normal practice, stop the investigations against us dead. And it would have done. That did not happen. It was quite dishonestly continued against us, and we were made to look stupid. We found ourselves being mocked and being made victims and scapegoats. Mrs. Weaver should be being investigated, and not us. So we now reach the conclusions, the final conclusions. Notice it, I'm not off duty yet. I'm still here. I'm not off duty. The conclusions in number of paragraphs. And here we go. Paragraph 1. There should not ever have been one single count of dishonesty or act or omission that leads or led to the forming of a dishonest view in an investigation or report relating thereto. To have 353 in 6 reports is simply unacceptable. That is what has been found in these investigations, and that gives rise to serious concern, especially in regards to the integrity of the investigation in question. Paragraph 2. After thorough review of the reports, it was clear that evidence that had been supplied by BT, AB and BB and submitted to the investigator, which he ignored or did not appreciate the importance of. We have found clear examples too. BT submitted the email sent to him by Councillor Susan Moore noting her and Councillor Smith's intention to call a meeting. This was accompanied by legal advice noting that this was not lawfully or legally acceptable requisition for calling a meeting. The email was viewed as being a bullying tactic to try to force BT to call a meeting by threatening to call a meeting themselves. It was clear that the investigator ignored this crucial piece of evidence without any reason. The assessment deemed that ignorance to be deliberate. 3. A further example of deliberate ignorance of evidence can be seen where the investigator overlooked and neglected something that was of critical importance. The evidence was submitted by AB and it pointed to there being a subject who could be deemed to be unsafe and a risk due to honesty concerns, which in turn made BT, AB and BB vulnerable victims. I'm going to name that subject because the assessment did. That subject was Councillor John Smith. The investigator cannot pick and choose here. He should have fully acknowledged it and investigated it as there was a very credible and real terms lead. Had he done that, he would have been alerted to a problem which would have proved fatal to the investigation. Due to his ignorance thereof, the investigator allowed that problem to manifest itself, which has now proven fatal for the investigation. 4. The investigator failed to consult with councillors regarding the rules of requesting the calling of meetings. Here, he correctly makes reference to the Local Government Act of 1972, but completely fails to acknowledge evidence put forward by BT vis-à-vis an unwritten rule which was and is still in situ on HPC. That rule is that any councillors who wish to request that the chair calls an extraordinary meeting must supply an agenda or agendae together with their requisition. In the case of the 10th of December 2020, that did not happen, which made those meetings even further unlawful, as was their calling and holding. It is clear that BT has advised the investigator of this rule, but it was ignored. He should have consulted with BT and quite possibly BB and AB, who had used this rule in August 2020 to call meetings. He simply didn't do that. He failed to consult, and it can be safely held and deliberately missed and ignored evidence. This serious omission led to a dishonest statement that the meetings had been lawfully called, and that there was no need for an agenda to be sent to the chair. This painted and gave an entirely false picture through this concerning and deliberate failure. 5. The investigator allowed statements accusing BT of attempting to block meetings to stand. There was no qualifying evidence whatsoever. He had taken no steps to qualify this and ascertain whether that was honest or not. All he had done was accepted the opinion of 3 counsellors, a clerk and Mrs. Weaver, who were all reading the same script and part of the same conspiracy. He had a duty to ascertain the veracity. There's that statement, that word again, veracity. Well, might need to look it up, John. Mind you, I believe your dictionary has only got painted pictures in it, so it might not have veracity in it, of those statements, and he took no action or any steps to ensure that was done. The assessment has held that he would let this statement stand, and that there was a distinct lack of acceptable fact-checking. The allowing of these statements to stand caused a defamation to BT. This is so because the statements were false. It was communicated to a third party via public publication, and the investigator and his instructing client were highly negligent in determining the truth of the statement. 6. The investigator failed to confirm the accuracy of statements made with evidence. In the interviews he conducted with counsellors Moore, Sampson, John Smith, Mrs. Jackie Weaver and Mr. Ashley Consky-Dawson, there were statements made which were opinion. Opinion cannot be admissible in evidence. In order for opinion to be turned to evidence, the investigator must qualify the validity and the truth of the opinion with evidence. His or her request for said evidence must be fully recorded in the reports. Remember those statements I said earlier? In this case, the reports were silent and provably false and dishonest statements allowed to stand. Again, that constitutes a failure to acceptably fact-check. The assessment concluded that the investigator had, through his own negligent failure, not checked or ascertained the truthfulness and accuracy of said statements. He wrongly accepted opinion as evidence. In publishing these statements, he caused a defamation to BT, BB and AB, as they were provably false, communicated to a third party via public publication, and the investigator and his instructing client were highly negligent in determining the truth of the statement. 7. The investigator falsely accused AB of bullying. The assessment found that when addressing whether or not conduct is tantamount to bullying, the definition of assertiveness and bullying should both be used to decide what heading the conduct falls under. He correctly cited the definition of bullying, but not that of assertiveness. Assertiveness is defined as being able to stand up for your own or other people's rights in a calm and positive way without being either aggressive or passively accepting wrong. Assertive individuals are able to get their point across without upsetting others or becoming upset themselves. The assessment looked to the facts and ruled that AB's conduct was on both occasions assertive and did not meet the criteria for bullying. I always knew I didn't bully anyone. In one case, AB had to battle the clerk who was conducting himself in an inherently dishonest manner in relation to public monies. AB had every right to communicate his concern as chair of finance and request to be furnished with bank account login details to ensure that nothing illegal or untoward was being done. AB stood up for the rights of others positively and calmly. He was not aggressive towards the clerk. AB did not seek to harm, coerce or intimidate the clerk, but in the face of serious illegality, he had to take action. To cite AB for bullying was false and defamed AB. Turning to the second accusation against AB, the assessment held this to be false and one that defamed AB. So again, I'm not guilty of bullying. This is in relation to the meeting of the 10th of December 2020, when he had to correct Mrs. Weaver, who quite correctly was in serious breach of the law. It is correct to say that AB was not calm and could be taken to have been aggressive, but provocation was not considered here. Provocation was clearly and heavily present that night and had been so prior to those meetings. Provocation is action or speech that makes someone angry, especially deliberately. It was abundantly clear that due to Mrs. Weaver's unlawful and unwarranted actions, that AB was clearly deliberately provoked. Mrs. Weaver, in her interview statements, admits she was there to see that the meetings went ahead. She even falsely stated that the meetings were lawfully convened and that this is what she believed. This is in contrast to emails sent by her to CEC members and a former CEC member in which she admits that she failed to check to see if the meetings had been lawfully convened. Either way, AB was assertive, but was also very badly provoked. The assessment held that AB did not bully Mrs. Weaver, as she knowingly and deliberately provoked him, hence why he reacted as he did. In the face of such provocation, it was held that it would be inherently difficult for any reasonable person to stay calm. Again, the investigator seemingly deliberately missed this critical evidence and published a dishonest and defamatory finding against AB. Paragraph 9. A false and wholly unproved allegation of swearing was made against AB. The assessment found that there was no evidence to uphold this and that this conclusion was branded as pure guesswork. If the investigator had viewed the correct video, which had not been subject to mutilation, he would have seen, as did the assessment, that when the swear incident occurred, that AB was simply not present on that Zoom call at the time. Since this false allegation, a voice recognition analysis has been conducted in which AB freely and willingly took part. The test came back negative and indicated that the swear did not come from AB. It was not his voice. Why was an analysis like this not undertaken by the investigator? This would have given rise to vital evidence and would have avoided the publication of a false and defamatory statement and finding against AB. The investigator and his instructing client must bear full responsibility for this catastrophic failure. So, no bullying, and I didn't swear. The video that was used by the investigator was tainted, this is paragraph 10, and manipulated, but yet he used it for assessment, which led to the publication of more dishonest conclusions. The assessment was provided with full unmanipulated videos of the meetings of 10th December 2020 and has considered them alongside the transcripts. The assessment found that the transcript did not match the full videos. Therefore, the evidence assessed by the investigator was tainted and therefore inadmissible. The assessment was fully noted that BT and BB did so advise the investigator that the videos he was using were false. The investigator clearly ignored this and dishonestly used inadmissible evidence as a means to publish dishonest findings. The assessment found this was very remiss and that there could be no defence afforded for an abhorrent failure to proceed with honesty and integrity. Paragraph 11. The investigator failed to appreciate and address credible evidence handed to him, which showed that dishonest opinions had been proffered by others. The assessment noted that this was an identical failure to that noted in paragraphs 2 and 3 above. His failure is fatal to the investigation, as it has no lawful standing, credibility, or integrity. He dishonestly published false and defamatory statements against BT, AB, and BB. Paragraph 12. The assessment also found that the investigator has falsely attributed statements and events to parties which had been found to be inherently dishonest. Again, unworryingly, this does constitute a failure to acceptably fact-check. The assessment concluded that the investigator had, through his own negligent failure, not checked to ascertain the truthfulness and accuracy of statements. He wrongly accepted opinion as evidence. In publishing these statements, he caused a defamation to BT and AB and BB, as they were provably false, communicated to a third party via public publication, and the investigator and his instructing client were highly negligent in determining the truth of the statements in question. Paragraph 13, we're nearly there. The investigator also permitted false and unproved allegations against named parties not involved in the investigation. He undertook no checks of any nature or kind to correctly ascertain the validity of the allegations. This was yet another worrying failure to acceptably fact-check or carry out any meaningful evidence check and search. The assessment concluded that the investigator had, through his own negligent failure, not checked or ascertained the truthfulness and accuracy of these statements. He warningly accepted this evidence. In publishing these statements, he caused the defamation to BT, AB and BB as they were provably false, communicated to a third party via public publication, and the investigator and his instructing client were highly negligent in determining the truth of the statements. Paragraph 14. The investigator abundantly failed to act on the admission of a criminal offence. Mrs. Weaver admitted that she had no lawful authority to act as she did in the meetings of 10th December 2020. This constitutes an admission of a criminal offence. The investigator is noted as practising public law, in which case he should have recognised this to be a breach of Section 11 of the Public Meetings Act of 1908. It is of great concern that this was missed and not recognised. The investigator should, on that admission being made, have researched the matter to establish whether or not an offence had been committed. Furthermore, so it was an opportunity to carry out a discovery and establish exercise, and it was missed. Furthermore, that admission is fatal to the investigation, and it should have been stopped and all complaints dropped instantly. This did not happen, and the investigator mendaciously went ahead. It cannot be accepted that he simply did not know that what he was doing was wrong. He simply should have known, acted accordingly, and ensured that he stated the truth in his findings. In the light of the above findings and in view of the findings of the assessment, ground 12 was, on the balance of probabilities, undisputably proved. And indisputably, yes. The assessment and our own investigations were both shown and were openly able to scrutinise and heavily examine evidence which showed that the investigator had 1. Published dishonest statements in the reports, 2. Aided and abetted the pursuit of dishonesty by parties to the investigation, 3. Made false and dishonest accusations against innocent parties without evidence, 4. Deliberately missed and ignored critical evidence, and 5. Not been even-handed or honest in his handling and reporting of the investigation. The assessment and our own investigations wanted it to be noted that investigations should be treated as a fact-finding exercise. They are not a witch hunt or an opportunity to prove any particular allegations. A good investigation will present any evidence obtained impartially, but in a manner which allows for any informed decision by any right-thinking, reasonable person. Whoever carries out an investigation is not there to prove the case, but to look for evidence which both supports and opposes the issues at hand. The overriding conclusion on this ground was that the investigator did not treat the investigation as a fact-finding exercise. It was turned into a witch hunt, predicated on absolute and unalienable deceit and chicanery. The evidence that was presented showed that not all evidence had been obtained, seized or discovered. Indeed, some critical evidence was ignored, and in some cases that ignorance was deliberate. It has been held that this investigator clearly was of the view and opinion that his role was to prove the case that BT, AB and BB had breached the code of conduct. This promoted dishonesty and was wrong. His role, which he did not understand, was to look for, acquire and analyse evidence which both supports and opposes the issues that were in hand. From the reports and their unbalanced state, the investigator did not look for evidence that supported and opposed the issues at hand. He openly took one side and was not fair or even. The assessment posed the question as to whether or not this stance was given to him by instruction from his client. This is a question that CEC and the monitor officer must answer in full and in a full and satisfactory manner. It is highly recommended that this is an action which is swiftly undertaken. I can tell you now that Cheshire East and that monitor officer have totally refused to answer that question to date. They will not answer it. They will not be open, honest and transparent with us. Finally, it was noted that the investigator did not fully report events as they happened during the investigation itself. He stated that one party refused to attend or agreed to do an interview with him in relation to the 10th of December 2020 meeting, but does not state why. He should have stated the reasons why. He was made fully aware of the serious breach of Article 6 Human Rights Act 1998 and that complaints had not been served, thus meaning a party could not defend themselves and thus not get a fair hearing. The assessment held the view that this admission promoted the taking of what was a dishonestly taken view that a party to the investigation had simply refused to cooperate. This was not the case, and the truth should have been reported accurately. In failing to report this, the investigator acted dishonestly in covering up a serious failing of his instructing client. Finally, on the balance of probabilities, it is found that there was a concerning and very high amount of mendacious practice both involved and promoted throughout the investigations. And the final part, to end the report, on the balance of probabilities and having seen all 12 grounds proved, the assessment has concluded that these investigations have no lawful standing, are therefore disqualified, and cannot stand or be used in any way against BT, BB or AB. There you have it, the full whack. And what I'm going to do now is, because I can do this now, I'm going off duty now. Yeah, I'm going off duty. I hope you've enjoyed this series. I hope you enjoyed these videos. It's not the last you'll see of me, but as I say, I'm off duty now. Take care. Thank you.